Cons- Constitution is a mechanism under which law is made, and not merely an act which declares that law is to be has been laid down by Supreme Court in Indian Cement Limited versus State of Tamil Nadu 1990, in which one the following case it was decided that preamble is not a part of the constitution. In Bedubadi case, in which case Supreme Court declared that preamble is a part of the constitution, Keshwanand Bharti case, in which case it was held at Supreme Court the preamble is a basic structure of the constitution, in Keshwanand Bharti case, in which one of the following case fundamental right, which one of the following case is known as fundamental right case, Keshwanand Bharti case. Judicial review of the ninth schedule of the Constitution has been permissible, by which one of the following case decided by the Supreme Court, I.R. Celio versus State of Tamil Nadu. Carry forward rule was held to be ultra vires, in which one of the following case, Devdasan versus Union of India. After which one of the following Supreme Court decision was a special provision for social educational backward classes introduced by amendment of the Constitution of India, State of Madras versus Champakam Dorirajan. It has been said that in many cases Devsan versus Union of India Article 16 should be read with Article 46 and 335, in which one of the following case Supreme Court held that Article 16(4)(a) provided for reservation in promotion is enabling provision, M. Nagarajan versus Union of India. Rajiv Kumar Gupta versus Union of India deal with the reservation in the state service for person with disability, which one of the following cases popularly known as Mandal case, Indira Swani versus Union of India, in which one of the case Supreme Court held that maximum limit of reservation cannot exceed 50%, Indira Swani versus Union of India. Creamy layer rule, excluding well-placed member of the caste from reservation, was first laid down in the case of Indira Sohani versus Union of India. Chronology order. M. R. Balaji versus State of Mysore, Akhil Bharatiya Shosith Karmchari Sangh versus Union of India, Indira Sohani versus Union of India, AIMS Student Union versus AIMS. Balaji Raghavan versus Union of India 1996, related to which one of the following article of the Constitution, Article 18. Which one of the following cases is not related with Article 19(1)(a) of the Indian Constitution, Khatai Ranging versus State of Susrut, in which one of the following case it was held at Supreme Court that right to trade on pavement in fundamental right, Sodhan Singh versus New Delhi Municipal Corporation. The scope of expression procedure established by law occurring in Article 21 explained in the case of Menaka Gandhi versus Union of India, in which one of the following case Supreme Court of India has observed sexual harassment in workplace as a violation of human rights, Vishakha versus State of Rajasthan, in which one of the following case Supreme Court of India recognized transgender person to a person of third gender, National Legal Service Authority versus Union of India, in which one of the following decisions Supreme Court of India has issued 16 guidelines regarding the investigation in encounter death, PUCL versus State of Maharashtra. In which one of the following case Constitution Bench of Supreme Court has, by majority of 4:1, held that review petition relating to capital punishment shall be heard in open court? Muhammad Arif versus Registrar Supreme Court. Which one of the following judgment related to prohibition against causing pollution and discomfort to public due to smoke at public place? Murali S. Devra versus Union of India 2002. In which one of the following case a Constitution Bench of Supreme Court of India has held that whenever a person complain and claim that there is a violation of any provision of law of the constitutional provision, it does not automatically involve breach of a fundamental right, for enforcement of which, along with Article 32 of the Constitution, is attract. Ramdas Athwal versus Union of India. Which of the following case was first case where strict adherence to the rule of locus standi was dilute? Rathilam municipality case. The object of the framer of Constitution of India was established with a general knowing welfare of the social status has been held in Motilal versus Uttar Pradesh Government AIR 1951. P.A. Sangma versus Pranab Mukherjee 2013 case decided by the Supreme Court with the majority of 3:2. Which one of the following cases associated with issue of domicile in the state concerned getting elected to the Council of State? Kuldeep Nair versus Union of India. The law declared by Supreme Court of India binding on all court within the territory of India, but the Supreme Court is not bound by the decision was decided by Supreme Court of India in Bengal Unity Corporation Limited versus State of Bihar. Which one of the following case in which Supreme Court has exercised advisory jurisdiction? In Re-Delhi Law Act case of State of Bihar versus Kameshwar Singh is related to which one of the following doctrine of color-labor legislation? Justice J.K. Puttaswamy, retired, versus Union of India 2017 was decided by a bench of 9 justices. In which one of the following case majority of judgment of Supreme Court held that Aadhaar not only gave the unique identity, only gave them the unique identity, but also a life dignity. Justice K.S. Puttaswamy, retired, versus Union of India. In which case Supreme Court has observed that social morality also changes from age to age. Nalsa versus Union of India. According to Supreme Court decision in S.R. Bomaya versus Union of India, Constitution of India is a federal. In which of the following case Supreme Court held that a state do not enjoy sovereignty under Indian Constitution as it does not provided for federal character in a strict sense? State of West Bengal versus Union of India. The Supreme Court of India described the Indian Constitution as not truly federal. In which one of the following case? State of West Bengal versus Union of India. It has been observed by the Supreme Court of India that word socialist in the preamble enable the court to lean more and more in the favor of nationalization and state ownership of the industry. Excelware versus Union of India. Legal sovereignty of India decide constitution itself and not in we the people of India. This ideology was expressed in Case 1 and Bharti case. Preamble is a part of basic structure in which case it was held. Keshwanam Bharti case. Preamble is a part of the constitution. This observation of Supreme Court was held in the case of Keshwanand Bharti versus State of Kerala. In Re Peduvadi versus Exchange of Enclave of Supreme Court held that preamble is not a part of the constitution. In the case of Golaknath versus State of Punjab, it was remarked that preamble contained in the nutshell its idea and inspiration. Justice Subha Rao. In which one of the following case Supreme Court held that preamble is not a part of the constitution? Bedubari case. Which one of the following cases upheld secularism is a basic feature of Indian constitution? Even the word secular was inserted in the preamble. Keswanand Bharati versus State of Kerala. In which one of the following case did the Supreme Court hold that preamble to the constitution is a part of the basic structure? S.R. Bommai versus Union of India. In Tinsukia Electric Company versus State of Assam, Supreme Court pointed out that the term socialist used in the preamble to the Constitution of India means state whose basic policy is to prohibit concentration of the wealth and upliftment of the standard of the people. Preamble of our constitution is of extreme importance, and constitution should be read and interpreted in the light of the grand and novel vision expressed in the preamble. Justice Sikri expressed the above opinion in the case of Keshwanand Bharti versus State of Kerala. The 7-judge bench of Supreme Court of India in Pradeep Kumar Viswas versus Indian Institute of Chemical Biology 2002 overruled the judgment in the case of Sabjit Tiwari, in which case for the first time Supreme Court had laid down certain principles to decide as when a corporation can be said to be an instrumentally of the state. Raman Dayaram Sethi versus International Airport Authority of India. The fundamental right can never be amended as it beyond the purview of Parliament. Such ruling was given in Golaknath versus State of Punjab. Clause 4 of Article 13 of the Indian Constitution was inserted by 24th Amendment Act 1971. It stated that Constitution amendment passed according to Article 368 of Indian Constitution is the law within the meaning of Article 13 and would according to be void if contravened the fundamental rights. The amendment was declared void in which one of the following case? Minaramas versus Union of India. In which one of the following case did the Supreme Court held that amendment of the Constitution under Article 368 of law within the meaning of Article 13 of the Constitution of India? Golaknath versus State of Punjab. Supreme Court of India formulated the doctrine of eclipse in Bikaji Narayan versus State of Madhya Pradesh. In which one of the following case it was held that law made under Article 368 would be subject to Article 13 Clause 2 like any other law? Golaknath versus State of Punjab. In law which is disqualified a person more than 2 children from holding the post of Panch Sarpanch is valid and not violative of Article 14 of the Constitution. In which one of the following case Supreme Court gave such decision? Javed versus State of Haryana. Supreme Court of India has adopted new approach for interpretation of the concept of equality in E.P. Rupaiya versus State of Tamil Nadu. Supreme Court of India decides Sri Likha Vidyarthi versus State of Uttar Pradesh. Right to equality under Article 14 of the Constitution. The new concept of equality as antithesis of arbitration was propounded first by Supreme Court in which one of the following case? E.P. Rupaiya versus State of Tamil Nadu. It has been held at Supreme Court that appointment of the candidate in excess to the notified vacancy is denial and deprivation of the fundamental right under Article 14, read with Article 16A, 1 of the Constitution in Ashok Kumar Chairman versus Banking Service Recruitment Board, in which one of the following case Supreme Court has declared Article 15 clause 5 of the Constitution as constitutional. Ashok Kumar Thakur versus Union of India, in which recent case law Supreme Court held that transgender fall in the category of social and economical backward class. Nalsa versus Union of India. The Supreme Court has ruled that person belonging to non-reserved class transplanted by adoption or marriage or conversion of any other voluntary act to a family belonging to reserved class does not become eligible to the benefit of reservation either under Article 15 clause 4 or 16 clause 4 of the Constitution. Valsma Paul versus Kochi University. After which one of the following Supreme Court decision was special provision of social and education backward classes introduced as amendment of the Constitution. State of Madrasa versus Chamkapam Dawai Rajan. Indira Sohani versus Union of India. Supreme Court held that there cannot be reservation in promotion, under which one of the following judgments Supreme Court directed the government constitute a permanent body in the favor of backward classes. Indira Sohani versus Union of India, in which case Supreme Court observed that equality of opportunity admit discrimination with reason of prohibited discrimination without a reason. State of Kerala versus N.M. Thomas, in which case Supreme Court was held that maximum limit of reservation cannot exceed 15%. Indira Sohani versus Union of India, in which one of the following case it was held that provision of Chapter 8 of CRPC being public interest and not violative of the Constitution of India. Madhu Lemle versus SDM Monghari. In which case did the Supreme Court hold that freedom of speech and expression granted under Article 19(1)(a) induced the right of information. Secretary Ministry Information of Broadcasting Cricket Association of Bengal. In Shreya Singhal versus Union of India 2015, Supreme Court struck down 1666A of Information Technology Act in entirely and violative of Article 19(1)(a) and not being saved at Article 19 clause 2. Being a juristic person, a company is not a citizen, but in which one of the following case Supreme Court held that state action empower the right of the company, thereby affecting the right of the shareholder. The protection of Article 19 will be applied to him. R.C. Cooper versus Union of India, in which case the 5 judge of Constitution bench postponed with aim to balancing the right of accused to be presumed innocent, completion of trial with a medical right and right of freedom of expression. Sahara India Real Estate Corporation and other versus Security Exchange Board of India. Supreme Court held that right to fly national flag with respect to dignity is a fundamental right of every citizen within the meaning of Article 19(1)(a) of the Constitution of India. Union of India versus Naveen Jindal. Which one of the following cases related to anti-strike verdict? T.N. Rangarajan versus Government of Tamil Nadu 2003. In which one of the following case constitutionality of Article 27 of Indian Evidence Act was challenged in the violation of Article 20 clause 3 of the Constitution. State of Bombay versus Karthik Alu, in which case Supreme Court of India held that polygraphy tests conducted under compulsion in the violation of Article 20 clause 3 of the Constitution. Shelvi versus State of Karnataka. As per the direction of Supreme Court of India, in a case of Shelvi versus State of Karnataka, compulsory use of narcotic analysis tests brain mapping, and polygraph test violate Article 20, Clause 3 of the Constitution. The provision of Clause 3 of Article 20 of the Constitution was not applicable investigating proceeding. The law is primarily come from the judgment of Supreme Court in which one of the following case: Kathi Kalu Ojha versus State of Shushruth. The case of Unni Krishnan versus State of Andhra Pradesh deal with which one of the following right is right of education. Supreme Court has upheld the following right as the Union of India versus Naveen Jindal: right to hoist the national flag. In which one of the following cases it was held that matrimonial right is not a violation of Article 14 and 12 of the Constitution? Saroj versus Sudarshan. In which one of the following cases Supreme Court held that strike by lawyer is illegal and unethical, and it infringes the fundamental right of litigant for a speedy trial? Lily Thomas versus Union of India. In which one of the following cases held that Supreme Court that the right of trade and payment of the fundamental right? Sudan Singh versus New Delhi Municipal Committee. Right of life does not include right to divorce, held in which case? Srimati Gilan Kaur versus State of Punjab. The Supreme Court of India held that right of life include right to enjoy unpolluted air and water was made in once in the following case: rural litigation and entitlement, Kedar versus Dehradun, State of Uttar Pradesh. After this case, Article 21 now protected the right of life and personal liberty of citizen not only for the executive action but also the legislative action. Maneka Gandhi. In which one of the following case held that Supreme Court Article 21 is controlled by Article 19? Mrs. Maneka Gandhi versus Union of India 1978. In which one of the following case Supreme Court held that right to sleep the fundamental right? In Ram Leela Maidan case. Which one of the famous case of Naj Foundation versus Government of NCT Delhi, section of the Indian Penal Code, whose constitutional validity of the challenge, section 377. In which one of the following case Supreme Court struck down section 66A of IT Act 2000, Shreya Singhal versus Union of India? In which one of the following case Supreme Court called Article 22 as an ugly provision of Constitution of India? A.K. Gopalan versus State of Madras. In which one of the following case Supreme Court observed labor taken from prisoner without paying proper remuneration comes within the forced labor? Dina versus Union of India. In which one of the following case Supreme Court has deliberated issued the guideline of child labor under Article 23 of the Constitution of India? MC Mehta versus State of Tamil Nadu, Bandhua Makti Morcha versus Union of India. In the case of John Walmington versus Union of India 2003, Supreme Court held that Section 118 of Indian Succession Act violative of Article 25 and 26 of the Constitution. In which one of the following case Supreme Court held that while guaranteeing the fundamental right and freedom of religion, explanation 2 of section Article 25 2b made it clear that reference of Hindu shall construct as include reference of the Persian provision Sikh, Jain, Buddhist religion, and the reference of Hindu religion institute the constructive accordingly. Sastri Yagan Pushdashi versus Mugdal, Budas, Vishwa. Which one is the leading case of freedom of religion? Bowie Art International versus OPS Hun. The conclusive part of Article 31C, and no law containing a declaration that for giving the effect of such policies shall be called the question of any court on the ground that it does not give effect of such policy, was struck down by the Supreme Court in the case of Keshwan and Bharti versus State of Kerala. Which one of the following case where the provision of construction of 42nd Amendment Act, which one gave the preceding of all the dying declarative principle of state policy and fundamental right, invalidated the Supreme Court? Minerva Miles versus Union of India.